May I be permitted to mention one matter, my lord? Well, this matter was mentioned yesterday, my lord. Your lordship was pleased to ask this matter to appear today as urgent motion, but it is not appearing, my lord.
What's the matter? What matter?
This was a new motion. It was filed. It was
New motion matter.
It was supposed to appear. It did not appear. It was
Department has not sent it. That's why it was not mentioned.
I am kindly, my lord. I'll take steps, my lord. Let it appear Monday as urgent motion. Otherwise, my lord,
Not necessary to mention it.
My lord, may I be permitted to mention one matter under to be mentioned, my lord? My lord, this matter, my lord, the respondent's advocate died and some of the respondent died, but we do not know the names of the legal heirs of this respondent. That is why, my lord, administrative notice should be issued by the court, landed court, and that is why, my lord.
What is this? Second appeal?
Second appeal, my lord. Second appeal, old second appeal.
Come on Monday. Today is not the day.
Well, it was mentioned, but only year was wrongly mentioned. That is why I am second time mentioning. It was already mentioned and accepted by your lordship. Well, let it corrected the year. It was written in spite of 1997-91. It was written.
Okay, call the list.
Yes, ma'am.
Group C. 72.
His
Your
lordship.
lordship, item number 72.
My lord.
May I have the leave to appear online, your lordship?
My lord, kindly bear me for a week, my lord.
Your lordship. I'm led by Mr. Victor Chatterjee on behalf of the petitioner.
Everyone has completed his submission, my lord. Only
Yes.
remaining is Union of India, my lord. My lord, I am seeking 1 week time, my lord.
What is the matter about? What is the matter? It is
Your lordship,
part-
absorption in the Jute Corporation of India.
Okay. Okay, this matter. Today you supposed to have
Only 1 week time, my lord.
very well. On the prayer of the learned advocate appearing on behalf of the Union of India, the matter be adjourned today. List the matter on 21st.
Deeply aware.
Grateful, your lordship.
No, 74, my lord, I am applying for things. My lord, although I am little bit unwell, my lord, today, my lord, I'll try to, my lord, complete as far as possible, my lord. Because your lordship is insisting of the matter, my lord.
Yes. I have heard the matter at lot.
Yes, my my lord, so far as my lord, the first matter is concerned, my lord, I have already, my lord, submitted and tried to portray before your lordship, my lord, how, my lord, these benefits were given, and my lord, since they are not entitled to their, my lord, benefit more beneficial than that of central government employee, so my lord, how it was, my lord, corrected. Now, my lord, in the earlier occasion, my lord, I, my lord, submitted before your lordship that, my lord, all these, my lord, my lord, corrective measures started from Milord 22nd of December 2005. But Milord, that was a general statement Milord made by Milord myself Milord. But Milord, I have gone through Milord all the Milord petitioners appointment, date of appointment. Milord, I find Milord some of them Milord joined prior to even 2005. So Milord, with respect to that Milord, I just modify my submission because Milord, the second writ petition Milord, all the Milord petitioners joined in the year 2010 November, sometime in November. But Milord, so far as the first Milord petition, Milord, this Anandamoy Adok and others, Milord, 3463W is concerned, Milord. Some of them, Milord, joined even prior to Milord 2005. So, Milord, with regard to them, Milord, the corrective measures, Milord, has been, Milord, done, Milord, prior to even, Milord, 22nd of December 2005.
Yes.
So, Milord, this is my, Milord, humble submission. Now, Milord, why these steps were taken, Milord? May I just rely on, Milord, office memorandum of, Milord, the Government of India. হ্যাঁ, দিচ্ছি। Yes. 2016. না না এটা গভর্নমেন্ট মেমোরান্ডাম অপোজিশন একটু দাদা এটা একটু জোর রেখে দেবেন Lordship may kindly excuse me, Milord. This is not paginated, Milord. I am just handing over, Milord, your Lordship this.
These documents were not given in the oppositions also, my lord.
Milord, this is the government, Milord, memorandum. Milord, I am just relying on this, Milord, because all these, Milord, decisions
Of 2016.
2016, Lordship.
We were neither pleaded in opposition, so we had no occasion to
No, Milord,
deal
this
with
is
these
the
also in our reply. We are
this
coming
is
at
the,
the
Milord,
first stage of the
This is a matter of recovery.
no, Milord, recovery.
This is
Yes,
in the matter of
Milord,
recovery.
recovery, but your Lordship is absolutely correct. Milord, but Milord, this particular Milord memorandum, Milord, takes care of Milord the judgment Milord placed by Milord my learned friend in other matter, Milord, that Rafik Mashi's case. Milord, this is your Lordship may not look into. The purpose of showing this was Milord, we Milord have to correct Milord take corrective measures. So far, Milord, it is come to our knowledge that somebody has got Milord benefit more than their entitlement. So Milord, these two Milord office memorandum is speaks about Milord that we have to Milord the autonomous bodies or the government departments have to take corrective measures immediately. Milord, whenever it comes to their knowledge that somebody is getting benefit more than their entitlement. That is Milord the purpose of Milord showing Milord this.
This is the exhaustive memorandum recording recovery of wrongful excess amount
Yes.
paid to
Milord,
the government servant.
Milord, yes. Milord, may I just indicate, Milord, few lines?
Since these have
You
been
are not now in the recovery process.
No, Milord, we have not recovered anything.
Then
We have
why
not
the-
recovered.
also
But Milord,
the
so far
group
as
of officers also not recommended
no.
it was not
Milord, so far as
approved by the
recovery,
state government or
Milord,
central government.
absolutely. Milord, so far as recovery is concerned, Milord, I am not placing.
Yes,
My purpose of placing this was, Milord, to
that the Bose Institute has the authority to issue circular for the system that some persons are
yes,
acquiring
yes.
more
Milord,
benefit
that is
than
all
they
right.
are entitled.
Yes, yes.
That's why you have issued
Milord, the
the
moment
circular on 22nd of
the
February
same thing.
2019.
Same thing, Milord. But Milord, this is more specific. It says that whenever it comes to within the knowledge of the government department or institute that somebody is getting benefit more than their entitlement, then corrective measures have to be taken. Milord, this is, Milord, in explanation to my, Milord, earlier submission that, Milord, we have, Milord, corrected them to their original post, and then, Milord, we have given all the benefits to them, including, Milord, the MACP and ACP benefits.
the difficulties with these documents were neither handed over earlier also, nor we are the first
Yes.
time. Last occasion also, my learned senior friend has resigned a service rule. They had not provided a copy. They have given a bunch of documents that was given. It's
Copy
very
I am
difficult.
handing over, Milord. There is no
we are-
problem with regard to handing over a copy.
Service rules are there in
The
the
service
Bose
rules
Institute.
were not given to us. Neither they were annexed in the opposition also.
Now the petitioner being the employee of the Bose Institute, they must have known about the service rules.
We have some issues, my lord. Then at the time of reply, we will be allowed to file certain documents since they are also differentiating those service rules also, my lord. Because these documents, my lord,
The service rules, my lord,
which they are now resigning at the final
all
stage
lying with
of
them.
the argument, these were not given to us. If those rules given to us before our stage of argument also, we could have stated those things. Now, at the time of hearing, certain documents are coming afresh. We are feeling very difficult.
Milord, this is, Milord, the mother rule, Milord, they are being guided. Milord, I am handing up a copy of this, Milord. Earlier occasion, Milord,
Service rules.
service rules.
Another document you have
Yes,
relied.
yes, already.
But
Milord, the
document
compilation
which-
of,
That is the other separate document. They are not,
Yes.
I am not taking those documents. This is the circular. What is the basis of the circular? That's why he want to say like that.
Milord, only, Milord,
Dated
to,
22nd of May 2020, 2019 as
yes,
Annexure P13
yes.
of your writ petition.
Your Lordship will, Milord, find, Milord, the instances of these, Milord, memorandums in various communications, Milord, of, Milord, which are being appended, Milord, to the writ petitions. Milord, I can, Milord, go into the detail, but, Milord, on the basis of those memorandums, Milord, these corrective measures have been taken. That is the purpose, Milord, of showing, because, Milord, I do not want to, Milord, suppress anything. Milord,
Okay.
whatever has been done, Milord, on the basis of these, Milord, things. Milord, now, Lordship may kindly have a look to, Milord. Milord, I will not take your lordship's much time bothering your lordship, Milord, to read the entire, Milord, circular. Milord, the only few, Milord, paragraphs or lines, Milord, I'll be just beseeching your lordship. Lordship may kindly.
It will be handed over to us, madam.
Yes, yes.
Give
Why?
me a copy.
No, this is, Milord, not at all an adversarial litigation, as my
If it is
learned friend
not
is.
if it is not at all
Considering.
essential, then let him not rely this document.
No, I am not saying it is not essential. I am saying this is not. Kindly do not treat this litigation as an adversarial litigation to such an extent that I will not hand over a copy which I am relying on.
Yes.
Now, Milord, may I just indicate, Milord, few lines of it? Lordship may kindly have a look to, Milord, paragraph 2. I need not bother your Lordship of the, Milord, notification dated 2nd of March 2016. It states about, Milord, taken consideration of Rafiq Mashi's case.
Yes.
So far as recovery part is concerned, and then, Milord, paragraph 2 and 3. 3 is, Milord, under what circumstances recovery is possible. Milord, that has been clarified. So, Milord, I am not going into detail of that by showing your lordship, because now, Milord, the recovery part is, Milord, we have not taken any steps as of now. because my lord, government's decision is not to recover as of now.
Yes.
But my lord, in the earlier occasion, my lord, I tried to point out before your lordship, so far as this Rafiq, as well as my lord, I'll distinguish Rafiq Smashi's judgment, why it is not applicable. Because my lord, all along, it was my lord done on the premises that my lord, they have also accepted that it is for the purpose of taking benefit, provisional benefit, provisionally, and whenever time comes, we undertake, we will return all those benefits. My lord, I have my lord, relied on several communications, my lord, appended to the first writ petition. Now, my lord, lordship kindly sees the second notification. My lord, just my lord, after that, my lord, it is not paginated, my lordship kindly excuse me. 6th February 2014.
Yes.
Lordship kindly sees, my lord, the same thing, my lord, happened in respect of my lord Chandi Prasad Unial versus State of Uttarakhand. My lord, this judgment also I am having, my lord. I'll be relying on, my lord, at the time of submission of judgments, my lord. My lord, there also, my lord, it carved out a difference that in case of fraud, negligence, carelessness, collusion, my lord, then my lord, recovery is possible. My lord, it has carved out, my lord, as an exception. Now, lordship may kindly skip over to, my lord, paragraph 2. My lord, this is, my lord, has taken care of, my lord, these judgments on the same line that after a gap of many years, recovery is not recommended because it will cause tremendous hardship, my lord, to the employees. My lord, that is, my lord, the sum and substance of the ratio laid down in these cases.
Yes.
Now, my lord, lordship may kindly skip over to, my lord, paragraph 3. The same judgment has been quoted, and my lord, may I just read, my lord, because this is this is important, my lord. May I just read, my lord, this. My lord, this judgment, my lord, takes care of, my lord, the issues, my lord, which have been quoted, my lord, Roman 1, 2, 3. Now, lordship, may I just read, my lord, Roman 1. In all cases where the excess payments on account of wrong pay fixation, grant of scale without due approvals, promotions without following the procedure, or in excess of entitlements, etc., come to notice, immediate corrective action must be taken. So, my lord, this is the purpose of, my lord, showing your lordship. My lord, this was the basis because, my lord, the government, my lord, came heavily on us, stating that you have done all these things. So, my lord, all these, my lord, responsibilities of the erring officials may be fixed, as, my lord, I have submitted earlier. So, my lord, immediately thereafter, my lord, when it has come to our notice, my lord, from the beginning, whatever amount they have got, my lord, if they are not entitled to, we took corrective measures. Now, my lord, so far as the first petition is concerned, my lord, I have submitted all. My lord, so far as the second petition, my lord, if your lordship kindly takes up the second petition, my lord, of Joyashish Ghosh. My lord, the first petitioner name is Joyashish Ghosh. করতে দে না। Why are you being annoyed? My lord, the so far as, my lord, the second petition is concerned, my lord, if your lordship kindly takes up, my lord, the prayer portion of, my lord, their second petition at page 22. এটা সেকেন্ডটা নাম্বারটা না 3460 হচ্ছে আনন্দময় যাদব, এটা জয়াশিস বণিক, এটা নাম্বার জয়াশিস 8008 থেকে জোসেফ ডাকছে 8008।
এইটা বলো তো, এটা নেই।
নতুনটা দিই। দিন ওটা দিন।
Yes.
Milord, so far as I have understood, Milord, their submission with regard to Milord this 8008 Milord petition number, Milord, their argument is based on a complete different footing altogether. Milord, they are not claiming that they are guided under Manas scheme. They are saying, Milord, that all along they have got promotional benefits under Milord career advancement program scheme, and Milord, on the basis of that, they were promoted to the higher Milord rank. Thereafter, their benefits have been curtailed and they have been downgraded, Milord. And Milord, in respect of one petitioner specifically, more specifically, they have submitted that in respect of one petitioner, he has been downgraded to a post. Then that Milord, he joined.
Yes.
He joined in a to an extent and he downgraded to a lower grade post. Milord, this is the sum and substance of their argument so far as I have understood, Milord. Now, Milord, Lordship may kindly have a look to Milord, page 22, their prayer portion.
Page 22.
My Lord. Page 22, brother. Page 22.
Yes.
Lordship may kindly have a look to Milord. The first prayer was with regard to refixation of pay and restoration of promotion. And Milord, they have Milord sought for Milord not to give effect to Milord the notification of our institute dated 5th of May 2020, which I relied on already, Milord, which is nothing but Milord, it has been culminated to Milord from the government's notification dated Milord 16th of October 2019. That Milord is the culmination of this. Now, Milord, they have prayed for restoration of all their benefits, refixation of pay and allowances, Milord, which they were enjoying. This was the first prayer. Then Lordship may kindly skip over, Milord, to the second prayer. They have sought for Milord setting aside of the government memo, Milord, which was passed on the basis of Milord the group of officers recommendation, 16th of October 2019. Then Lordship kindly sees their Milord prayer with regard to interim relief is same, more or less Milord akin to their main prayer. Now, Milord, Lordship may kindly have a look to the date because these are necessary. Milord, this particular writ petition was filed, Milord, in the month of, if I am not wrong, subject to correction, Milord, in the month of September 2020. Lordship kindly takes care of this because Milord, later on I'll submit Milord why I am relying on. Because
Yes.
Milord, all is Milord, all the petitioners' prayer based on that restoration of promotion and Milord service benefits since they have been downgraded. Now, Lordship may kindly have a look to Milord. Milord, I have prepared a chart, Milord, of their Milord joining as well as Milord their benefit. If your Lordship kindly takes up this, Milord, I am just handing over a copy also. একটু দিন তো। Lordship may kindly have a look at Milord. The first name is Joashish Ghosh, petitioner. Milord, what is his date of joining? That is Milord, 24th of November 2010. He joined as Milord junior lab assistant. Milord, his date of promotion, Milord, original the first promotion was my lord with effect from my lord 24th of November 2015.
Yes.
My lord, I have tried to explain your lordship. My lord, all these persons, my lord, got benefit. My lord, either my lord 5 years, my lord, residency period, or my lord, as per my lord, their own entitlement they have got. But it was not vacancy based, my lord, because my lord, vacancy based promotion, my lord, requires my lord minimum my lord 10 years residency period. My lord, I have my lord tried to show your lordship, my lord, from recruitment rules itself. Now, my lord, lordship, may I kindly have a look to my lord initial my lord pay and he joined. You know, his scale of pay was 9,300 to, you know, 34,800. Plus, you know, his grade pay was 4,200. My learned friend, my lord, has relied on, my lord, heavily on this because, my lord, he said, my lord, he has been downgraded after, my lord, this. My lord, my humble submission is, my lord, he has never been downgraded. My lord, he joined as junior lab assistant. He was, my lord, we, my lord, took, my lord, consideration of all his, my lord, promotions. He was not entitled to be promoted, my lord, in, my lord, 5 years of his residency period. So, my lord, ultimately, my lord, lordship may kindly take note of this, my lord, his date of joining in the year 2010, 24th of November. So, my lord, his residency period completes in the year 2020, my lord, as per his entitlement in the month of November. So, my lord, calculating that, my lord, he got his promotion, that is, my lord, MACP promotion, my lord, I must say, because, my lord, 2020 there was no vacancy arose, because there were, my lord, promotion, my lord, given to them, these petitioners. They were given promotions in the year 2020 November, or, my lord, the date of joining 10 years after completion they have got promotion. So, my lord, I have, my lord, tried to point out before your lordship, my lord, the basic premises of petition is, my lord, this petition was filed in the year 2020 September. So, my lord, it was also not possible for them, my lord, to state before your lordship that they were promoted already, my lord, in the year 2020 November. So, my lord, this fact was not there. That is why, my lord, I am trying to point out. My lord, they got promotion, MACP, my lord, benefit in the year 2020 November. And thereafter, my lord, all subsequent, my lord, benefits of promotion were given to them. Notional benefit and this. Now, my lord, lordship,
It is the
kindly,
submission that they have got promotion in the year 2015.
that was wrongly, my lord, given. We took,
So they are enjoying the benefits. Now by the such notification, they have downgraded.
yes.
You are submitting that they are not downgraded to their original place of posting, That is the GP at the time of
They are now enjoying, my lord, 4,200 GP. Grade pay. Grade pay is same.
GP is same.
GP is same. Now, my lord, the difficulty, my lord, I tell you, lordship, it may. Bol.
Was reduced. Then probably November, they are saying it is after 10 years, now
They are saying that according to the MACP, the
after 10 years,
justice is entitled to get after 10 years the promotion.
so no promotion. Rate pay was restored to 4,200 because it was joined at 4,200. It was reduced further.
Reduced.
Reduced further.
Well, my submission is no.
They are repeating it.
No, may I just clarify that? My learned friend, Milord is saying, Milord, no. Dada bolo. Lordship, may kindly have a look to their pay slip. It will be clear, Milord, from there. Lordship, kindly have a look to, Milord, the pay slip appended to, Milord, at page 73. Lordship, kindly see the date of the pay slip. Milord, this pay slip was relied on. Milord, the date is, Milord, May 2020, when he did not get, Milord, MACP benefit. So, Milord, it is showing, Milord, his level in matrix, Milord. Matrix, Milord, is because of, Milord, the 7th pay commission. Milord, grade pay was changed to, Milord, pay level and pay matrix. Milord, grade 6, Milord, is equivalent to, Milord, 4,200. Which was in, Milord, 4,200 in, Milord, under 6th pay commission. That is, Milord, grade 6 in 7th pay commission. So, Milord, he has never been downgraded. This is my humble submission.
No,
Now,
grade 6, 4,200.
Milord, there are Milord pay band, Milord 4,200, 4,600, then Milord 4,900 and 5,400.
Yeah.
There are 4 grade pay, Milord. Now, Milord, this Milord, I do not have the chart, Milord. If I have, Milord, I'll just rely on Milord. Today, Milord, I'm a little bit crippled, Milord. Milord, I'll Milord show it to your Lordship, Milord. This is Milord equivalent to Milord level 6 of Milord under the 7th pay commission. So, Milord, he has never been downgraded. Milord, the confusion arose because of the fact, Milord, I must clarify, Milord. Milord, all this confusion arose because of the fact, Milord, this Milord junior lab assistant, as per recruitment rules, Milord, recruitment rule says junior lab assistant's grade pay should be 2,800. That is, Milord, the main confusion here. But, Milord, as per advertisement, Milord, my learned friend has relied on, and as per his date of joining letter, it will show that he joined in the grade pay of 4,200. So that, Milord, there arises the confusion, because 2,800 is his actual grade pay entitlement as per recruitment rules. But, Milord, he joined in 4,200. Now, Milord, he has never been downgraded to 2,800. He has been, Milord, to its original position of 4,200.
Okay, and
Now, Lordship may kindly have a look to, Milord, page 75, because, Milord, these particular, Milord, two organizations, Milord, pay scales were relied on, Milord, while, Milord, submitting before the group of officers by the employees union or, Milord, the staff representative. Milord, page 75, Milord, Lordship may kindly have a look at, Milord. They have annexed in this writ petition, it has been annexed. So, Milord, may I just point out from here. Lordship, kindly see, Milord, they have prepared a comparative chart of Bose Institute with DRDO.
yes,
DRDO is, Milord, Defense Research Development Organization, and, Milord, DAE, Milord, Atomic Energy, Milord, Department. Now, Lordship, kindly sees the residency period. Milord, they have mentioned 5 years, although, Milord, in respect of Bose Institute, but, Milord, I have, Milord, submitted in the earlier occasion. From the recruitment rules, Milord, it is 10 years. 5 years, Milord, they are mentioning because of, Milord, the scheme which we implemented and subsequently set aside by the government of India through, Milord.
Manas.
No, Milord, Manos has never been given effect to. Milord, I, Milord, tried to rely on, Milord, the scheme, career advancement scheme,
Yes,
Milord, appended to the first writ petition. Milord, that was, Milord, given effect to by us, Milord, through an office memo, Milord, which has said that this particular scheme, career advancement scheme, will start on and with effect from 22nd of December 2005. So, Milord, that was the point of, Milord, juncture where from these benefits were given.
5 years benefit.
That has been, Milord, set aside by this, Milord, impugned memo dated 16th of October 2019, Milord, issued by the Government of India on the basis of, Milord, the recommendations of group of officers. So, Milord, this particular residency period which they are, Milord, relying on, is my humble submission, is not correct, because this, Milord, takes care of, Milord, the career advancement scheme which has been subsequently set aside due to the fact, Milord, this gives a better benefit than that of a central government employee. Actually, Milord, the Bose Institute employees should be governed by their recruitment rules, which is their, Milord, mother rule. The mother rule, the parent rule says, Milord, 10 years residency period. So, Milord, this particular chart is, Milord, my humble submission, wrongly, Milord, prepared.
Yes,
Now, Lordship may kindly takes care of, Milord, the middle column, that is, Milord, DRDO, Milord, employees, Milord. Milord, DRDO has also separate recruitment rules. Milord, in the earlier occasion, Milord, I submitted before your Lordship, Milord, DRDO has a specific rule. Their jobs and responsibilities are different. And, Milord, the posts are also different. Milord, some of the posts are common, although. But Lordship, kindly see why I'm saying it is different. Milord, the residency period, Milord, mentioned is all, Milord, 5 years in respect of DRDO. So, Milord, their jobs and responsibilities and, Milord, jobs and responsibilities of these institute at least cannot be, Milord, my humble submission, compared with, because, Milord, the vacancy, Milord, is based on, Milord, three things. Milord, one is, Milord, the actual vacancy. Milord, second is, Milord, the residency period, And third one is, the appraisal report. Now, the residency period in respect of DRDO as well as, DAE are different from, both institute. So, my humble submission is this, this is also not applicable, in respect of, both institute employees. So, ultimately, government, has taken into consideration the staff representative submission and the chart prepared by them. But, they had no occasion, to deal with this because this is completely different with, our employees. So, it has not been, there is no reflection. Your lordship will not find a single reflection, with regard to, the comparison, they have given.
No,
They are,
they want to substantiate the comparison to show that they are also getting the same benefit which DRDO and DAE are getting.
yes, they are,
That they want
yes.
to demonstrate before
I bow
the
down to your lordship.
group of officers.
Yes, their submission is based on the fact that, we, introduced career advancement
Yes, I
scheme.
understand.
Career advancement scheme speaks about residency period of 5 years.
Their argument, the career advancement scheme for 5 years
Yes, which is,
not
similar to
incorrect.
DRDO.
Is not incorrect, they are saying.
My lord.
They are
Well.
saying that is not incorrect back because the benefit they are getting at par with the DRDO and DA.
My lord. My lord.
That is their submission.
Well.
And you are saying that the CAS, that is the career advancement scheme, was
Struck down, by
struck
the
down
government
and
because of the fact
illegally given.
we have, separate recruitment rules which speaks about, 10 years residency period, which is not similar to these two organizations. Now, lordship may kindly have a look to their rules for a moment. They have, annex. I am thankful, to my learned friend, he has annex. Lordship may kindly have a look to page 77. Schedule 3. This is DRDO rules. Lordship may kindly have a look to this because DAE, I have, already submitted.
This is the rules of DRDO.
DRDO, Lordship kindly sees, the residency period, mentioned is 5 years. Only in respect of technical officer D, it is 6 years. And in respect of DAE, there are different residency periods. In respect of DAE, 3 years, 4 years, 5 years, 6 years even. In the earlier occasion, I've tried to submit. And from the chart itself, it would appear, the last part of the chart at page 75. In respect of DAE, some of, in respect of 3 years, 4 years, 5 years, even 6 years. Now, lordship may kindly have a look to page 44. This is the appraisal report. One of the petitioners, petitioner number 1's appraisal report has been annexed. I'm just relying on this, just to clarify the position here. This was up till 31st of December 2018. Your lordship will get the period at the top of it, from 1st of January to 31st December. Lordship kindly sees at that juncture he was enjoying the designation of senior lab assistant. He joined as junior lab assistant. His promotional avenue gives him benefit up to senior lab assistant. His grade pay was at that juncture was 4,600. He joined initially at the grade pay of 4,200. And 9,300 to 34,800 was his pay band. Now, Lordship may kindly have a look to Milord, page 29. Milord, this is the initial Milord letter of Milord appointment. Offer of appointment, Milord, rather, Milord, I would say. Milord, the offer of appointment letter dated Milord 16th of November 2010 at page 29.
Yes.
Lordship may kindly have a look to Milord. The same Milord, grade pay 4,200 has been mentioned. Junior lab assistant, pay band 2, 9,300 to 34,800. And Lordship kindly sees the terms and conditions of the appointment are as follows. Milord, I will not go into the detail. Lordship kindly take note of point number 2. Your service will be governed by the Bose Institute service rules. So, Milord, all of them are, Milord, governed by the recruitment rules. Milord, service rules, Milord, is the recruitment rules part 2, Milord. So, Milord, all their, Milord, promotions, Milord, will be governed under this Bose Institute service rules. So, Milord, different organizations of government, Milord, has different, Milord, rules, service rules. Like DRDO has their own service rules as they have, Milord, annexed. And Milord, DAE is also different. And Milord, the residency period mentioned in the service rules are also different, Milord. In respect of, Milord, our institute, Milord, it is 10 years, Milord, in respect of the petitioners. Now, Lordship may kindly have a look to page 37. Milord, this is, Milord, the document they are, Milord, relying on, dated, Milord, 25th of January 2018. Milord, giving a, Milord, comparative chart of their, Milord, existing pay band, promotional pay scale, as well as, Milord, the post with effective date, Milord, mentioning there. Lordship will kindly see it starts with, Milord, in pursuance, page 37. 7, 5, 3.
There is the order of promotion.
Yes. Milord, on the basis of this, they are claiming all this, Milord. Milord, may I just read, Milord? In pursuance of the recommendations of the Departmental Promotional Committee, Milord, this DPC has a, Milord, right, Milord, to recommend, Milord, promotion as and when, Milord, the vacancy arises. Milord, normally, Milord, DPC sits every, Milord, year twice. Milord, in the month of July, Milord, it sits well in advance, Milord, the vacancy arises. Milord, even, Milord, suspecting that vacancy will arise, Milord, DPC will sit, Milord, well in advance. So, Milord, on the basis of recommendations, normally, Milord, these kind of promotions are happen. In pursuance of the recommendations of Departmental Promotion Committee, in their meeting held on 21st of December 2017, the director officiating Bose Institute is pleased to accord approval for non-functional in situ promotions of the non-academic staffs mentioned below in terms of career advancement scheme stroke promotional rules of Bose Institute and subsequent circular dated 5th of December 2013, office order dated 16th of September 2014, and corrigendum number dated 16th of September 2014. Now, Lordship, kindly take an example as the petitioner number 1 is mentioned in column number 5, serial number 5, Joashish Ghosh. He joined as junior lab assistant, pay band 2 with grade pay of 4,200. His promotional pay scale was 4,600. Grade pay, the same pay band. Promotional post was senior lab assistant as he was, Milord, given. And, Milord, the effective date of 24th November 2015, that is, Milord, 5 years residency period.
After 5 years.
Yes. So, Milord, he got that benefit. Likewise, Milord, the other petitioners also got the benefit because almost, Milord, they have joined, Milord, in the year 2010, sometime in either November or in April or, Milord, March. Now, my lord, may I, for the, my lord, at the cost of repetition, I am just relying on, because they have appended, my lord, this particular scheme. Lordship may kindly have a look at page 33. My lord, on the basis of, my lord, this scheme, my lord, they got promoted at page 33. This is, my lord, the career advancement scheme, which, my lord, in the earlier occasion also I submitted, my lord.
Yes.
There, my lord, the residency periods are mentioned in respect of different pay scales. Lordship sees 5 years. Scale 1 to 4, 4 years, 5 to 7, 5 years, 8 to 10, 5 years.
5 years.
You know, these were আসছি আসছি দাদা ওটা তো আসছি আসছি ওটা তো আসছি।
December 2013, that was referred to in the promotional order. That is at page 39.
Milord 39, Milord, my learned friend is saying, Milord, I am coming to that also, Milord. Milord, the entire basis of, Milord, this career advancement scheme is, Milord, page 32, and 32's enclosure is, Milord, page 33.
That is April 15, 2008.
Yes. Lordship, kindly see, in continuation of the office memorandum dated 8th of April 2008, the salient features of revised pay structure and career advancement scheme of non-academic staff, both administrative and technical of the institute, at par with ISCS Kolkata, are attached herewith. If there is anomalies, that will be sorted out in conformity with ISCS Kolkata by a committee to be constituted by the director of both institute.
Group
So,
of
Milord, this was the,
officers has said that the 8 April
yes, Milord, 8th April,
and 15 April
yes.
memos are illegal.
Yes. Milord, I am grateful, Milord. Your Lordship will get, Milord, 8th April's memo, just previous to that page, page 31.
Page 32.
Now, my lord, coming back to, my lord, once again, my lord, at page 39, if your lordship have a look to, because my lord, they are also relying on this. My lord, this was the circular dated 5th of December 2013, my lord, issued by the registrar, my lord, at that juncture. My lord, may I just read? Promotion should not be considered as a matter of right. Rather, it is to be earned by the incumbent. The present system of reporting and reviewing do not present the true and fair picture of level of competencies and skills of the incumbent. The incumbent to be promoted is to be evaluated rigorously and thoroughly, whether he or she is really capable, stroke competent enough of handling the responsibilities of the promoted designation, stroke scale of pay, with a view to enhance efficient and effective work environment, and on recommendation of the committee constituted video order number so and so dated 31st of May 2013 for promotion of non-academic staff of the institute. The director Bose Institute is pleased to issue the following instructions for implementations of the existing promotion policy of the non-academic staff, administrative stroke technical. The minimum residency period linked to performance for promotion to following pay band and grade pay as mentioned below. Lordship, kindly see pay band 2, Milord, 4,200, residency period is 5 years. Milord, my humble submission, this cannot be done. Although, Milord, the circulars was issued, but it was beyond, Milord, our, Milord, scope and ambit, because, Milord, our recruitment rule says it is 10 years. In all future promotion, administrative and technical, a promotion assessment committee has to be constituted. The promotion assessment committee will have their own assessment, taking into account the report as whole, and should not be guided by the grading given by the reporting stroke review officer. In some cases, such grading may not be consistent with the content in the report. Promotion assessment committee will give their final grading as outstanding, very good, good average, and unfit as may be applicable in the relevant case. The benchmark for promotion up to grade pay of 6,600. This is similar. Your lordship may kindly skip over. My lord, Lordship kindly see, my lord, thereafter, my lord, the middle portion. Incumbents to be promoted from GP of 4,200 to GP 4,600 and above would be assessed by the interview process through an assessment committee comprising external members in majority. Incumbents between grade pay 1,800 to grade pay 4,200 would be promoted on the basis of their annual assessment report, grading as per the recommendation of promotion assessment committee. All non-academic, including technical staff, for promotion from grade pay 4,200 to grade pay 4,600 and above would be evaluated through an interview process by an interview panel to ascertain their competencies and skills in their respective functional area, that is administration or technical, that are required to take up the responsibilities on promotion to the next higher designation stroke scale of pay. In the interview panel for promotion of administrative and technical staff, external experts having relevant expertise in the concerned relevant functional area would be in majority in these committees. Then, my lord, the minimum educational qualification mentioned.
Yes.
So, my lord, their basis was that you either have to be 5 years residency period for getting promotion, then, my lord, the interview will take place, and, my lord, promotional committee will take a decision on the basis of, my lord, their performance in the interview. My lord, that was the sum and substance of, my lord, the circular.
Yes.
Now, your lordship may kindly consider, my lord. Now, my lord, my learned friend has submitted, my lord, written notes of submission, my lord, which will clarify, my lord, the basis of, my lord, their submission, my lord. If your lordship kindly have a look to, my lord, their written notes for once. My lord, they have mainly raised some of the issues, my lord, which I tried to clarify, my lord. Lordship may kindly have a look to, my lord, the written notes, my lord, submitted by them, my lord.
Yes.
I mean, not a compilation type, my lord.
Yes.
Lordship may kindly skip over to, my lord, internal page 5, paragraph 12. My lord, the issues have been mentioned there. My lord, I will take your lordship, my lord, to that, my lord, one by one. Lordship may kindly have a look to, my lord, 12A, whether Bose Institute, being an autonomous organization, had the authority to fix the categories of post, pay scales, and promotional policies for its employees. B, whether the respondents have the authority to withdraw, cancel the office memorandum dated 8th of April 2008 and 15th of April 2008 and withdraw all benefits accorded thereunder after a long 12 years period and restore the position of 2005 and direct for recovery of overpayment, if any. My lord, these two, your lordship may kindly have a look at what is their, my lord, contention at paragraph 13. My lord, regarding issue number A, whether we have authority to do or not, my lord, they have relied on, my lord, article 309 and 311. And, my lord, they have, my lord, relied on two decisions of Honorable Supreme Court, my lord, reported at 2015 volume 5 SCC and 2019 volume 4 SCC 113. Now, lordship kindly sees, my lord, their contention with regard to this is that Bose Institute, being an autonomous body, have got powers to frame terms and conditions of service of its employees. and the benefits to be made available to them, and the employees of the autonomous organizations are not governed by Article 309 or 311. And therefore, there was no legality in the office memorandums dated 8th of April 2008 and 15th of April 2008. And the promotional policy stroke rules dated 5th of December 2013, just now I have quoted at page 39 of their petition. Even if those give some additional benefits to the employees of the Bose Institute than that of the employees of the central government, in this connection, the petitioners rely on the judgment so and so. Now, my humble submission is this, this autonomy, the scope and ambit of the autonomy, we are enjoying. In the earlier question, I tried to, show your lordship, is not, unfettered. These autonomy is curtailed by, time to time several notifications, that 2019 notification, 2020 notifications, which clearly says that we can take decisions although, but subject to some, criteria being fulfilled. The first thing, we cannot create post. We cannot, create burden on the government exchequer. We cannot, take any decision, or our employee cannot enjoy any benefits than that of central government. In support of that, I have relied on, the general financial rules, 2017, rule 230. Because, all these funds are being provided by the government, subject to audit. We cannot take any decision, against, government's policy decision. Because, there is also, section 4, comes into, steering on our face, of the Controller Expenditure Act, which says that we cannot do anything out of our own. Even, government department has to take decision in financial matters in consultation with other department, that is finance department of the government. So, these, by way of this, I try to show your lordship, we do not enjoy, autonomy, to such an extent that we can, give promotions to them, or, give benefits to them, which are, more beneficial than that of central government employees.
Yes.
Now, if your lordship kindly look at, their, judgments at, page, the first judgment is between Punjab State Electricity Board versus Thana Singh, 2019, volume 4. Your lordship will get at,
I got it.
the page number is not there. Lordship, kindly see at the above,
Yes, I got it.
one. Grateful one. Lordship, kindly see, they are relying on, paragraph 18 of the judgment only.
Yes.
But, for the sake of convenience, I'll say, lordship, kindly be, see, what was the actual, fact, which
Issue
was
involved.
issues involved. Lordship will kindly have a look to, paragraph 2. Brief facts of the case are as follows. The respondents were inducted into the service of Punjab State Electricity Board in the year 1978, and now they are working as sub-fire officers in the appellant board. The pay scale of post of sub-fire officers was so and so, which was revised with effect from so and so date. Thereafter, by an order dated so and so, the pay scale to the for the post of sub-fire officers was revised to so and so with effect from so and so, along with pay scales of other category of employees of the board. For example, head clerks, head clerk cum divisional accountants, and internal auditors were revised. Subsequently, by an order dated so and so, the pay scales of head clerks was revised from so and so to so and so on the recommendation of the pay anomaly committee. Likewise, by the same order dated so and so, the pay scale of internal auditors was revised to the scale of so and so, but the pay scale of the sub-fire officers was not revised on a par with head clerks and internal auditors. So, the basic premises of this judgment was, there was discrimination in respect of revision of pay scales with respect to, same class of staffs.
Yes.
That was the subject matter of consideration. Lordship, kindly see, my humble submission, this, cannot be, a facts and situation here. Here, we are acting on the basis of government's decision, so that, all these staffs, it is not, there is a reasonable, discrimination between a same class of people. It is, government is taking a decision that all these staffs should be in conformity with the central government employees' benefit. So, the facts and situation, my humble submission is different. Although, lordship, may kindly have a look to paragraph 18, which they have tried to rely. The same thing says, my lord, we also do not dispute about this because this is, my lord, the actual, my lord, ratio, my lord, Honorable Supreme Court has laid down. Lordship, kindly see, my lord, paragraph 18 says, the appellant board being an autonomous body governed by its own regulations. My lord, Lordship, kindly sees, my lord, this is a state autonomous body. My lord, the state autonomous body is different, my lord, my humble submission, from central autonomous body, because central autonomous body is bound by GFR. State autonomous body is bound by their own regulations. Like, my lord, this Punjab Electricity Board has its own regulations. We, Milord, give, Milord, funds, Milord, to the autonomous bodies, so they are bound to, Milord, the government rather gives, Milord, fund to autonomous bodies, so, Milord, the autonomous bodies are also, Milord, bound by the government's decisions. And how they are bound, Milord, I have, Milord, tried to portray before your Lordship. Now, Lordship kindly sees paragraph 18 says, the appellant board being an autonomous body governed by its own regulations, it was for the board to classify its employees to posts on the basis of qualifications, duties, and responsibilities of the post concerned. Milord, pausing here for a moment, Milord, an autonomous, central autonomous body cannot, Milord, create any post, or, Milord, cannot classify its own employees or post. Because, Milord, all these, Milord, functions are ultimately lying with the government of India. If the classification has reasonable nexus with the scales, Article 14 of the Constitution of India would be applicable only when a discrimination is made out between the persons who are similarly situated and not otherwise. So, my lord, this was, my lord, the actual, my lord, ratio laid down here. I will not bother your lordship, my lord, the other, my lord, observations made in the paragraph, because my learned friend is relying on this. My lord, my humble submission, the facts and situation here is totally different, my lord. So, my lord, the ratio is not applicable here. Now, my lord, they have relied on another judgment on the same score, my lord. Lordship kindly sees, my lord, the judgment reported at the very next judgment, my lord, 2015, volume 5, SCC 353. Lord, they have mentioned, my lord, the relevant paragraphs as paragraph 5, 6, and 7. My lord, at the top of it, it is marked 2, my lord. Lordship kindly sees, my lord, the facts and situation is, my lord, mentioned at paragraph 4. Briefly stated, the facts are as follows. The respondent, Dr. Swanso, was working as additional professor, Department of Surgery, Postgraduate Institute of Medical Education and Research, Chandigarh. The Government of India, Ministry of Home Affairs, Department of Personnel and AR issued an office memorandum dated so on the subject of relaxation of upper age limit for departmental candidates in government departments, giving relaxation of a maximum 5 years in the upper age limit for recruitment to other Group A or Group B post through an advertisement by the commission. So, my lord, there, my lord, relaxation was given, and this relaxation was given by whom? Lordship kindly sees, Government of India itself, my lord, gave relaxation through office memorandum. Here, my lord, the case is completely different. Here, my lord, government is, my lord, saying you have to take corrective measures. Now, Lordship kindly sees, my lord, the relevant paragraph they have mentioned, paragraph 5, 6, and 7.
Yes.
Aggrieved thereby, the Union Public Service Commission filed a writ petition before the High Court as aforesaid. By the said order, the High Court was of the view that the post held by the principal respondent was akin to the government servant, and therefore he is entitled to the relaxation. The High Court was, however, of the view that the provision of Article 311 of the Constitution of India do not apply to the employees of the institute. Before the High Court, it was the case of the commission that Dr. Swanso was overage as on the cut-off date, and he being not in government service was not eligible for the benefit of the cut-off date, benefit of relaxation. The said contention was repelled by the High Court, holding Dr. Swanso entitled to the relaxation on a par with the government servants. It is not in dispute that the postgraduate institute in which respondent Swanso and Swanso was serving in a creation by an act of parliament, and as such, it is an autonomous body. However, the services of the respondents were not covered by the proviso to Article 309 of the Constitution. Article 311, as held by the High Court, was also not attracted in their case. Therefore, in our considered opinion, it cannot be held that the respondents are government servants. The benefit of office memorandum dated so and so, upper age limit of departmental candidates for appointment to Group A and Group B post cannot be legally extended to the service conditions of Dr. So and Dr. So. Thus, the contrary view taken by the High Court, holding both the respondents entitled for the benefits of relaxation in terms of the aforesaid office memo, is erroneous and cannot be sustained. The appeals are allowed in the aforesaid terms. The orders of the High Court as well as orders of tribunal granting benefit to the respondents shall stand set aside. We may clarify that in the meantime, if any benefit of the order of relaxation has been given to so and so, shall not be withdrawn for them. Now, my lord, this is, my lord, a complete different scenario where, my lord, the question of granting relaxation, my lord, on the basis of a particular government memo was, my lord, considered by the Honorable Supreme Court. And, my lord, the Honorable Supreme Court, my lord, ultimately states that no, this particular, my lord, office memorandum is erroneous. My lord, the contrary view taken by the High Court, and it cannot be sustained. And ultimately, appeals are allowed. But, my lord, so far as this particular case is concerned, my lord, the question is, my lord, we are, my lord, following a government's decision based on, my lord, general financial rules as well as, my lord, other office memorandums issued by the, my lord, government of India.
Yes.
My lord, we do not have any contradiction with regard to government's view. My lord, the case referred to here is different from, my lord, our case. My lord, my humble submission. Thank you. আমি নিয়ে নিচ্ছি। করে দিচ্ছি, হ্যাঁ। Now, Lordship may kindly have a look to, my lord, these are, my lord, two my lord, issues, my lord, they have, my lord, relied on. Then, my lord, may I just again, my lord, come back to, my lord, page 6 of the written notes of argument. My lord, the other issues, my lord, issue number C and D.
Yes.
Whether under any circumstances the respondents have jurisdiction and stroke or authority to revert the petitioners to a status which is lower than the status of their initial joining to the Bose Institute. Whether the Department of Science and Technology could have given a retrospective effect to the purported decision arrived at by the group of officers in respect of the petitioners with retrospective effect from a date which was prior to the joining of the petitioners. My lord, these two issues, my lord, have been dealt with, my lord, conjointly at page 7, my lord, paragraph C. My lord, may I just read, my lord? Paragraph C, my lord, they have stated, the petitioners joined the service in 2010 pursuant to the selection process conducted by the Bose Institute, offering pay structure settled under memorandums dated 8th of April 2008 and 15th of April 2008. And the petitioners accepted such offer in such circumstances. The effect of the directives dated 16th of October 2019 and the implementation thereof by the Bose Institute by a circular dated 5th of May 2020 sought to revert the position of the petitioners to a position which was not even the status of the petitioners at the time of their joining, that is reversion to a cadre lower than their joining cadre, and that not under the any disciplinary proceeding which is not at all permissible in law. My lord, pausing here for a moment, my lord, they have relied on two decisions of the Honorable Supreme Court. My lord, this particular, my lord, issues, my lord, is not German before this Honorable Court in this particular matter, because, my lord, I have tried to show your lordship, they have never been downgraded to their, my lord, position to a position which they joined. Now, my lord, so far as your lordship's query is concerned, my lord, I have prepared another chart, my lord, although, my lord, I am bothering, but, my lord, it is required, my lord, just your lordship may kindly have a look to, my lord. This is a comparative chart of, my lord, 4th CPC, 5th CPC, and 6th CPC. My lord, the pay level, your lordship was, my lord, asking me, my lord. Lordship may kindly have a look to this, my lord.
Can application.
My lord, I'll clarify that. My lord, my learned friend is submitting. I will clarify that also. Now, Lordship, may kindly have a look to my lord. লোকটা হলে দেবো লোকটা যখন বলবো তখন দেবো Milord, Lordship, may kindly skip over to the last page, Milord, the schedule of Milord 7 CPC, Milord, pay matrix, Milord. Lordship, kindly sees at the top of it, Milord, may I just explain to your Lordship, Milord? The grade pay has been mentioned, Milord, 4,200 your Lordship will get. The pay band is 9,300 to 34,800. As Milord, it is mentioned, Milord, in various Milord paragraphs as well as Milord the pay slips.
Grade pay 4,200.
My Lord.
Level 6.
Yes, level 6. It is equivalent to level 6.
Level 6.
Now, Milord, I will compare with Milord page 73 they বললাম না?
That is their pay scale. That is their
Pay slip, Milord. Lordship, kindly compare this with page
slip.
73.
pay slip.
Yes, pay slip. They were never been downgraded, Lordship. This is equivalent to Milord pay level and pay matrix. Level 6. Page 73, Milord, the right hand side column. Level in pay matrix.
Level in pay matrix 6.
Level 6. And Lordship kindly takes note of Milord the pay matrix is 46,200. Milord, same will Milord come Milord if we calculate Milord. The designation is junior lab assistant. Milord, so there is Milord, my humble submission, there is no financial Milord curtailment Milord with regard to Milord their grade pay or Milord pay level. They are enjoying the same benefits. Milord, from November 2020 onwards, Milord, they got Milord MSCP benefit and accordingly Milord, they are enjoying that salary. Only Milord, humble submission as my learned friend is pointing out, Milord, the regarding Milord the designation. As Milord, they have mentioned in their application. Did the application paste over?
That is scan 1 of 2022.
Level 5 downgrade হয়েছে?
This is the order which was passed subsequent to the filing of the return. Not to try to come to the bottom. Which one laboratory assistant? They were first advantage of junior laboratory. Subsequent. But thereafter, by a order dated 16/6/2020, they were downgraded to level 5.
একটু দাম
Five. Pay level 5 because of the top.
Yes. Serial number 16.
or serial number 6. There are the new decision. About the cases.
Okay.
15 is the stenographer.
Milord, right hand side bottom, Milord, my learned friend.
Okay, okay, okay.
Milord, may I just clarify this, Milord?
Junior laboratory assistant, A level 5. After the repetition. Okay.
Milord, may I just clarify this? Milord, so far as Milord, this particular memo is concerned, Milord, may I just read, Milord? This is Milord memo dated 16th of June 2021. The Governing Council in its 200th virtual meeting held on 30th April 2021 approved the revised APAR format. Milord Rashid kindly takes note of this. This is appraisal report format. APAR format for maintenance of uniformity to be issued from the calendar year 2021 to non-academic, both administrative and technical staff of the institute as per designation stroke level of pay as mentioned below, all formats attached. So, Milord, this is for the purpose of, Milord, only revised APAR format. Milord, the confusion arises because of the fact, Milord, in case a vacancy-based promotion happens, Milord, the person who is entitled to vacancy-based promotion, Milord, he is upgraded to the next, Milord, hierarchy. So if he is, Milord, joined as a junior lab assistant, Milord, ultimately vacancy arises, and if he fulfills the criteria of Milord, vacancy-based promotion, Milord, there are three, Milord, ingredients, Milord, I have this, Milord, submitted. Then, Milord, he will be promoted to, Milord, senior lab assistant. Here, Milord, what happened? He got only MSCP benefit. MSCP benefit, Milord, takes care of stagnancy. MSCP benefit, Milord, gives, Milord, the benefits of his grade pay. His grade pay remains same, but unless and until he is promoted on the basis of, Milord, vacancy based promotion, Milord, ultimately in his APAR, Milord, it will automatically show that he is getting, Milord, level 5, Milord, benefit, because, Milord, the level 5 is, Milord, your lordship will get, Milord, the same comparison mentioned in the recruitment rules, because, Milord, my initial submission was, Milord, the recruitment rules, Milord, specifically provides the grade pay of 2,800, not, Milord, 4,200. Milord, but, Milord, there was an error occurred, Milord, during, Milord, the advertisement. Milord, the advertisement, Milord, speaks up, Milord, 4,200, Milord, grade pay. Milord, we have never, Milord, downgraded him, Milord, to the below, Milord, 4,200 grade pay, Milord, which is apparent, Milord, from the pay slip of May 2020. Milord, I can produce, Milord, the pay slip, Milord, of, Milord, the latest pay slip also. Milord, he has never downgraded to, Milord, level 5. Milord, this
What
level
is
5,
this? Why the memo is this?
yes, Milord, this level 5,
Upper. This is
yes,
the upper.
APR, Milord, only for the purpose of appraisal report. Because this annual performance appraisal report, Milord, is calculated on the basis of his designation. Milord, till today, Milord, he is designated as junior lab assistant. Unless and until, Milord, he is promoted to the next hierarchy, like, Milord, the senior lab assistant, Milord, he cannot, Milord, go to the, Milord, it will not, it will never show, Milord, level 6. But he is getting, Milord, the benefit of level 6, Milord. His, Milord, payslip will, Milord, prove that. Milord, this designation he will get once he is promoted, Milord, on the basis of vacancy-based promotion. Milord, that probably maybe the confusion, Milord, arises here. Because, Milord, the level 5, a person, Milord, will not get that much amount, Milord, as he got, Milord, in even, Milord, calculating even, Milord, in year, Milord, May 2020.
They were promoted. By way of a selection process. Thereafter, my lord, in on May 5th, 2020, my lord, they were reverted back to the post of. They had worked in the post of for a period of 4.5 years. So the question of MSCP that was subsequent to the subsequent.
Yes, yes, I understand. But
And not
it is their argument that you have got the promotion in the year 2015 on the basis of a scheme
On the basis of
which was not approved by the central government.
and I participated in the selection process. There was a selection process of interview part. And that we have, we shall.
According to the scheme, you have appeared in the interview. All the appraisal reports are there. Yes, yes.
Now, Lordship, may kindly have a look to Milord the same chart, Milord, the comparison, Milord, the last Milord part, Milord. Milord, just to show your Lordship, Milord, what is Milord the actual grade pay of Milord level 5? Lordship kindly sees level 5 grade pay is 2,800,
2,800.
but he is not getting 2,800. He is getting 4,200.
All along, he is getting 4,200.
Yes. It is only for the purpose of Milord annual appraisal report, annual performance appraisal report. Milord, this Milord label is shown because Milord he up till now is working as junior lab assistant. Once Milord vacancy based promotion happens, if he gets Milord vacancy based promotion, he will automatically Milord go Milord his appraisal report will show Milord his designation as senior lab assistant. Milord, that is the confusion Milord here arises Milord. Milord, his pay slip proves that Milord he is getting Milord 4,200 grade pay. Now, Milord, so far as Milord these two issues are concerned, Milord, I was just Milord submitting before your Lordship, Milord. Issue number, Milord. আজকে একটু হেল্প করলে পারিস যদি হয়ে গেল। Hello, so kindly excuse me, but I was just searching. Page. Delete it off now. Lordship, may kindly have a look to Milord, page 6, paragraphs C and D, Milord.
Yeah.
Milord, this is the same issue, Milord, which I was Milord trying to point out. Milord, they are saying, Milord, they have been reverted to a position, Milord, than Milord, the date of their joining. And Milord, they have relied on two Honorable Supreme Court's decision. Milord, I am not bothering your Lordship by reading the entire because the ratio is Milord the admitted position. A person Milord cannot be Milord reverted to a position then Milord the date of joining Milord he was enjoying. So Milord there is no dispute with regard to Milord this Milord two Milord Supreme Court decisions. But Milord my humble submission is Milord the ratio is not applicable here because they have never been reverted to a Milord pay scale Milord which is Milord more Milord Milord downgraded to
Lower
a
than
scale
the-
lower than that of their
their
joining scale. So, Milord, I need not Milord, bother your Lordship by Milord, reading these two judgments, Milord. Now, Lordship, kindly see, Milord, issue number E and F. My learned friend has quoted, Milord, at page 6, whether the Bose Institute could withdraw the promotion already granted to the two then petitioners in 2018 pursuant to the communication of the Department of Science dated 16th October 2019. And F is whether the directive dated 16th of October 2019 of Department of Science and Technology for recovery of alleged excess payment could be applied to the petitioners under the facts and circumstances of the present case. Now, Milord, in support of these two, Milord, my learned friend has Milord quoted Milord at page 8, Milord, the answer. May I just read, Milord, with regard to issue E. Paragraph D, Milord states, as already stated above, Bose Institute, being an autonomous body, has power to classify posts of its employees and also the pay structures for such posts. Change of policy of the central government was not automatically applicable to Bose Institute, and therefore the decision dated 13 January 2017 of the Department of Finance was under no circumstances could be applied retrospectively. And the Bose Institute was also not bound by the said decisions. In any event, the Office Memorandum of Finance Department dated 13 January 2017 was not applicable for any promotion already given. The petitioners were promoted to the post of senior lab assistant under merit cum seniority based selection process as per subsisting promotional rules of Bose Institute video circular of 2013. My lord, I have already placed page 39 of the writ petition. Therefore, neither Bose Institute nor the respondent number 2 were legally authorized to cancel the promotions given to the petitioners, that too without affording them any opportunity of hearing, as the withdrawal of promotion in the present case amounted to alteration in service conditions. In this regard, the petitioners rely on the judgment of Honorable Supreme Court. My lord, National Thermal Power Corporation judgment, my lord, Lordship may kindly have a look to 2007, volume 14, SCC 234. Now, my lord, I tried to submit before your lordship that, my lord, Bose Institute has only those, my lord, autonomy which, my lord, the government, my lord, provides for. My lord, it cannot create post, or my lord, it cannot give benefits something more beneficial than that of the central government. Now, my lord, based on that submission, if your lordship kindly takes up, my lord, this particular judgment, relevant paragraphs are paragraph 34 and 35. My lord, paragraph 34, it, my lord, has quoted, my lord, P.R. Chand versus Omkar Lakshman's case, my lord, held in, my lord, by the Honorable Supreme Court. It says, my lord, paragraph 8 has been quoted, a contract of service being thus incapable of transfer unilaterally, such a transfer of service from one employer to another can only be effected by a tripartite agreement between the employer, the employee, and the third party, the effect of which would be to terminate the original contract of service by mutual consent and to make a new contract between the employee and the third party. Now, my lord, this is, my lord, probably not applicable to this case because it is a completely different text altogether. Lordship may kindly skip over to, my lord, paragraph 35. The government or its instrumentality cannot alter the conditions of service of its employees, or any such alteration causing prejudice cannot be effected without affording opportunity of pre-decisional hearing, and the same would amount to arbitrary and violative of Article 14. As pointed out earlier, in the case on hand, the employees are neither party to tripartite agreement nor they have heard before changing the service conditions. Therefore, the action of the management is violative of Article 14 of the Constitution. Similar view has been taken by this court in HL Trihen versus Union of India. In paragraph 11 of the judgment, the court observed as under. It is now a well-established principle of law that there can be no deprivation or curtailment of any existing right, advantage, or benefit enjoyed by a government servant without complying with the rules of natural justice by giving the government servant concerned an opportunity of being heard. Any arbitrary or whimsical exercise of power prejudicially affecting the existing conditions of service of a government servant will offend against the provisions of Article 14 of the Constitution. Admittedly, the employees of Coril were not given an opportunity of hearing or representing their case before the impugned circular was issued by the Board of Directors. The impugned circular cannot therefore be sustained as it offends against the rules of natural justice. So, my lord, this particular, my lord, judgment or ratio, my lord, laid down by the Honorable Supreme Court on the basis of the fact, my lord, there government, my lord, entered into a, my lord, tripartite agreement, and, my lord, curtail, my lord, the employees, my lord, right by, my lord, without giving them any opportunity of hearing. My lord, my humble submission, these particular facts is not applicable here because, my lord, the twofold reason. My lord, first of all, my lord, all these decisions are, my lord, in concurrence with government's decisions. And, my lord, well, my lord, after granting them an opportunity of hearing by formation of a group of officers. My lord, before the group of officers, my lord, I tried to submit before your lordship. My lord, the staff representatives representation was there. My lord, they have been heard. My lord, they were present there. My lord, after, my lord, due deliberation, my lord, then, my lord, government took a decision, and on the basis of that, my lord, even that, my lord, their right or entitlement has not been curtailed. My lord, we have streamlined their, my lord, benefits to such an extent which there is actual entitlement. It is not beyond that. My lord, here, my lord, their, my lord, uh, rights have been curtailed. So, my lord, my humble submission, this decision cannot be, my lord, applicable here. Here, my lord, we have not curtailed their entitlement. We have streamlined to such an extent they are entitled to. But they have not been reverted. It's a correction or, my lord, the corrective measures that has been taken.
Yes.
Now, my lord, the most, my lord, important, my lord, judgment, my lord, they have quoted in page 9, paragraph E, my lord, while dealing with, my lord, issue number F, my lord, framed by them. My lord, it is, my lord, quoted as, my lord, the directive dated 16th October 2019 of Department of Science and Technology for recovery of alleged excess payment could not be applied to the petitioners under the facts and circumstances of the present case. In any such directives are against the law settled by the Honorable Supreme Court. Even assuming, but without admitting, that excess payment has been made to the petitioners from their respective dates of joining, even then, since such payment was not due to any fault or suppression at the instance of the petitioners or on the basis of any fraud committed by the petitioners, no recovery could be ordered by the respondent number 2. In this connection, the petitioners rely on the judgment of Honorable Supreme Court delivered in case of State of Punjab and others versus Rafiq Mashi, reported at 2015 volume 4 SCC 334, and Milord Thomas Daniel versus State of Kerala, which is a subsequent one, Milord, stating, Milord, the same facts reported in, Milord, 2020 SCC online SC 536. Milord, we are also not disputing that, Milord, recovery, Milord, cannot be done, but under certain circumstances, the criteria has to be, Milord, fulfilled. When, Milord, recovery can be done, Milord, there has to be a fraud, ingredients of fraud, or, Milord, there has to be, Milord, some ingredients that hardship will cause, my lord, to the employee. My lord, how, my lord, hardship will cause, my lord, that has been mentioned, my lord, in Supreme Court, similar Rafiq Mashi's judgment, and subsequently, my lord, this Thomas Daniel. My lord, a person who is going to retire, if his, my lord, retirement benefit is curtailed or, my lord, taken away, then, my lord, hardship will cause. Or, my lord, a poor employee. Here, my lord, Supreme Court has mentioned, my lord, to which extent recovery can be done. And, my lord, with abundant caution, my lord, I have also submitted, my lord, that, Nil, these particular, my lord, cases, my lord, I will just take your lordship, my lord, to only one paragraph of the facts of the case of this Rafiq Masi's case. My lord, assuming that, my lord, this particular ratio is applicable for us, my lord, even that also, my lord, the facts and situation was different. Here, my lord, the entire premises is based on the decision taken by the institute on the basis of, my lord, the clear understanding that this is, my lord, allowed provisionally with a rider that you will return, or rather, my lord, they gave undertaking that we will return. In case it is not applicable for us, we will return. My lord, the formation of, my lord, taking decision in the year 2008, my lord, I tried to explain through, my lord, the governing council's meeting and all. My lord, there, my lord, it shows, my lord, there was a clear understanding with the employees that they will return all the benefits if they are not entitled to. My lord, all along, my lord, this rider was there. And, my lord, your lordship will not get, my lord, subject to correction a single line where, my lord, the institute took a decision without any rider that this benefit is being given to you as per your entitlement. My lord, all the, my lord, decisions were taken with a rider subject to approval comes from Government of India. Even, my lord, the Mana scheme, even, my lord, this appraisal scheme, career advancement program scheme, all these schemes, my lord, although, my lord, Mana scheme has no sanctity from government, but, my lord, be that as it may, all this, my lord, was given with a rider that's subject to approval. My lord, this particular approval is required because, my lord, the Ministry of Expenditure, Finance, my lord, has, my lord, the burden, my lord, in case, my lord, we take any decision, my lord, which is more, my lord, congenial to them, but, my lord, which is, my lord, against government's directives, my lord, as specified in general financial rules. My lord, so, my lord, this particular decision is also, my lord, my humble submission under the similar set of facts, my lord, I could have understood, but here, my lord, all decisions, my lord, with a clear understanding that I am giving an undertaking, I will return all the benefits. Lord, this is not the scenario in this Rafik Mashi's case either, or, my lord, in Thomas Daniel's case. Level 7 at the case, no?
Rafik Masian, Thomas Daniel in respect of the recoveries.
Recoveries. Well, here we have not taken any steps. My lord, your lordship, when your lordship will taking up, my lord, the matter relating to the pensioners, will your lordship will get a notification. There is a specific, my lord, clarification given by the government of India that will not recover. My lord, waiver can be done only under the, my lord, expenditure if Department of Expenditure permits. So they have asked, my lord, to ask for, my lord, waiver of the recovery. So, my lord, I'll rely on that. Since, my lord, recovery is not an issue here, my lord, I'm not going into the detail.
Yes.
My lord, only one thing, my lord, so far as, my lord, my learned friend's submission, if your lordship, my lord, I have come up with all the pay slips of, my lord, the second writ petitions, my lord, current pay slip. Current pay slip now. My lord, this is related to March 2021 for the sake of convenience because, my lord, from March 2021, my lord, they already got, my lord, MACP benefit. Lordship, kindly have a look to their pay level. They are in pay level 7.
Level in matrix 7.
7. They have got MACP benefit. They are in pay level 7. But, my lord, for the appraisal, annual performance appraisal report, it will show, my lord, level 6, level 5. As per their, my lord, designation and recruitment rules. Close করে দিচ্ছি। So, my lord, to sum up, my lord, the entire issue, my lord, twofold, my lord, prayers have been made in both the petitions. My lord, the petitioner, the first petition is based on, my lord, mana scheme, which I have tried to point out, my lord, how it is not applicable. The second petition is based on, my lord, completely a different scheme, my lord, by which, my lord, they got residency period of 5 years and they were promoted to, and my lord, their commission is they have been downgraded to a pay scale, but it is not that, my lord. I have tried to show, my lord, by way of producing pay slips, and my lord, the only, my lord, the effect is, my lord, they are showing, my lord, for the purpose of calculating, my lord, their annual performance appraisal report level 5, but my lord, they are getting the same benefits, my lord. There is no financial curtailment. They are getting the same grade pay equivalent to, my lord, level 6. Now they are in level 7. Level 7, my lord, is of senior laboratory assistant. But
After MSCP, they got level.
yes, after. But they have not got the designation, because, my lord, designation they will get only, my lord, vacancy arises
It is a vacancy
as per
response.
their seniority and appraisal they will get. Now, my lord, the facts and situation is,
Yes.
in the institute, my lord, we have, my lord, as and when, my lord, the vacancy arises, my lord, the senior most gets an offer that you have to either you accept or not. But since, my lord, due to pendency of this, my lord, some of them have not, my lord, acceded to our request. Some of them has my lord, accepted. Well, this is the situation, my lord, going on. Now, my lord, to sum up, my lord, I will not rely on any further decision of the Supreme Court, because, my lord, Supreme Court judgment, most of them are relied on with regard to the recovery part.
Yes.
My lord, now, if your lordship, post me any query, my lord, I'll, my lord, or my lord, otherwise, my lord, I am completed, my lord, my submission. My lord.
Okay, very good. Not necessary. I have heard.
Grateful. My lord.
We shall be giving reply to the Union of India and Bose Institute next Thursday, my lord.
Next Thursday.
Next Thursday. Okay.
Now, what is the prayer of can?
My lord, the prayer in can is, my lord.
Just a clarification. We are more public clarification. This senior, they are not. They are are giving promotions. And that is what, because the scheme was, cannot, that's a different issue.
Now, what is the residency period? You are saying it is 5 years, and they are saying according to the recruitment rules, it is 10 years.
That has to be.
Yes.
That has to be.
No, this is the submission of
Yes.
parties.
Great, Lord.
Next Thursday, please take down. Argument on behalf of the Bose Institute concludes. Let the matter be fixed on 21st for the reply on behalf of the petitioners.
Grateful, Lord.
দুটো গুছিয়ে রাখা লাগবে এটার সঙ্গে সব আগেরটা প্রথমেরটা ঠিক আছে all parted matters. The group 6. 76 টা দিন 76 আবার ডাকুন লিস্টটা দিন আইটেম নাম্বার 76 লিস্টটা দিন না লিস্টটা করুন না লিস্ট আছে বলছে আইটেম নাম্বার 76 টা লিস্টে তুলুন লিস্টে নেই তো লিস্টে 82 রান করছে Now these are also Bose Institute matter, I think.
Your Lordship. It is.
76.
Your Lordship.
Yes, my Lord. My Lord, 76 is also same. But my Lord, these are not related to, my Lord, the technical, my Lord. Probably these are related to administrative, my Lord. Lordship may kindly adjourn this, my Lord, after, my Lord. See, the Lordship is in ceasing of these matters, my Lord.
No, 76 and 77 both are the same. 76 is the Arunabha Ghosh. And Bose Institute and Union of India is there.
Yes, my Lord. My learned friend is appearing, my Lord.
I beg to appear on behalf of the petitioner.
Yes.
I'm led by Mr. Ghosh in this matter. But the issue is similar, only the designation which
Breathe in.
ministry.
Yes, that was, my Lord, I was submitting.
Same, my lord. It was a conscious decision was arrived at. The benefits were given. There was no indication that this decision of giving the promotion and consequential benefits is subject to approval by certain authorities. After that, 13 years passed. We make our life in a particular manner.
and one fine morning, it was withdrawn.
No, it is the same two notifications are there.
Same. My lord, only my lord, the jobs
They are the
responsible.
administrative.
They are
staff.
administrative.
Administrative staff, my lord, we will be minutely only rely upon the relevant facts, not in a broad manner. And my
So
lord, we will
let the matter be finished first, the
Yes,
first
my
two
lord.
matters.
My humble submission, it will, my lord, it would be easier for us also, my lord, if your lordship takes up, my lord, these matters after your lordship passes a judgment on the first two, because it will cover everything. Or, my lord, if it is made for,
I have to hear them, otherwise I cannot pass any judgment of any matter.
my lord, with regard
Otherwise-
to, no, my lord, with regard to the administrative post, my submission would be slightly different. If your lordship takes up, my lord, as a whole,
It would be better to hear out all the
Grateful.
petitioners
grateful, my lord.
separately thereafter.
Separate. Grateful.
So let the first two matters, 72 and 73 be concluded first. Okay. 74 and 75. Thereafter, I will start 76.
My lord.
And who is the 77? These are
77 my lord, another my lord, Prafullo Bhaiya. My lord, Prafullo Bhaiya আছে না?
are they the same issues are there?
Yes, this is also administrative, my lord.
They are
77
also the administrative.
administrative.
And who are the persons of the retired employees?
My lord, retired employee Mr. Arunangshu Chakraborty is appearing.
Whether
Yes.
it is in this matter.
My lord, this is only with regard to the recovery part. But it will not take much time, my lord. The pensioners matter.
Very well. Let the matter be appear in the list. Let the matter be appear in the list on 21st.
On conclusion of the first two matters, then our matter, my lord.
I am not passing that order.
No, not it.
Yes, on conclusion of
My
the
lord,
that matter has been concluded. I think on the
Only
Thursday,
petitioners
next Thursday
reply.
it will be concluded.
We will then.
Then you can start. Okay, you get ready on. Okay. Okay, next matter.
my lord, only 79. My lord, up till 79, same order may be passed, my lord.
77 to 79. Same order.
Same order. 77 and 8 with regard to administrative, 79 my lord, pensioners, my lord. Huh? Each.
77, 78 and 79. Same order.
Same order. Grateful, my lord.
All separate order will be there.
Yes, my lord. Grateful.
Yes, sir. 80, madam, I'm the petitioner, my lord. Even the last occasions, I have completed my submission. So the respondents are there to start their submission. But this is regarding, my lord, forfeiture of the gratuity amount of the petitioner. And she's almost like above 65 years old lady. And the forfeiture was done not in conformity with the even Durgapur project limiters rules, and also I'm also in contrary to the Payment of Gratuity Act. So it was fixed, my lord, but on 7 November.
Today, the affidavit in opposition was not placed. That's why I directed the respondent to reaffirm the affidavit in opposition.
They haven't submitted, my lord?
No, they haven't submitted yet. Your reply is placed on record,
Yes, yes.
but their opposition was not there.
I don't know, surprisingly, I have the copy of the affidavit of opposition.
Yes, yes.
But it is the marked one. And don't know why it is not in the file.
And you have used the reply also.
Yes, yes, ma'am.
You have used the reply.
And the matter has been going on, madam, for a long time, and
I
this
understand.
petitioner is eagerly waiting for some relief from your lordship. And
who is appearing for the state, Mr. Sushanto Pal, represented on the last day.
The issue here was, my lord, that there was no provision of terminations as
75% was imposed.
imposed and
Reduction of
she retired,
75% of the gratuity amount was imposed.
Yes, and it was
You have challenged only
forfeited.
that point.
Yes, and for 70% has been forfeited, and the fact is that she was retired from the services. It was not an event of termination, so it does not even comply with the provisions of the Payment of Gratuity Act in for the forfeitures thing. And secondly, my lord, they have in fact imposed this punishment, which is completely contrary to their own rules, service rules that I have showed, my lord, last times, the Durgapur Project Limited. So the forfeiture is nowhere mentioned in the list of their punishment. So they have done in contrary to their own rules. And secondly, they haven't quantified anything, the damages and all these things, and arbitrarily just imposed this punishment, my lord, without even verifying or even quantifying the loss and damages.
You have showed me the rule.
Yes, my lord. I showed the rules, my lord. This is
Rule
it's rule 44, my lord. Punishment for misconduct.
acts of misconduct.
Yes. So nowhere it is mentioned about the forfeiture thing, my lord. And it's a disciplinary action they have initiated. That is, my lord, rule 45, sub rule 6. That if on inquiry the employee is found guilty of the charges or charges, the finding is accepted by the punishment authority, he may be awarded of any of the punishments as mentioned in Rule 44 in consideration of the gravity of the misconduct, previous record, and or any other extenuating or aggravating circumstances that may exist. So that comes under Rule 44. So Rule 44, my lord, it says that without prejudice to the provisions of any law for the time being in force, an employee who is found to be guilty of an act of misconduct or indiscipline is punishable as outlined below. One is censure, 2 is fine, 3 is withholding of increment or promotions or without cumulative effect according to gravity of offense. 4 is reduction to a lower class grade post or stage in time scale specifying or without specifying any period of operation. 5th is discharge from the services, and 6 is dismissal. So nowhere is mentioned forfeiture.
Forfeiture of gratuity.
Yes, madam. Even the Payment of Gratuity Act, madam, I had shown the section 4, madam, subsection 6.
Where is the Payment of Gratuity Act?
The Gratuity Act. Yes.
You are referring subsection 4.
Subsection, section 4, subsection 6, madam. Section 4, subsection 1, I should start, my lord.
Yes.
That gratuity shall be payable to an employee on termination of his employment after he has rendered continuous service for less than 5 years. That is on his superannuation.
Yes.
Or on his retirement or resignation or on his death or disablement due to accident or disease. So this is, my lord, the rules for gratuity. And for the forfeiture thing, my lord, it is mentioned under section subsection 6. that notwithstanding anything contained in subsection 1, the gratuity an employee whose services have been terminated for any act, willful omission or negligence causing any damage or loss to or destruction or property belonging to the employee shall be forfeited to the extent of damage or loss so caused. So, yes.
I am appearing on behalf of the state.
Yes, today it is your turn to submit.
No, I am not. I am appearing on behalf of the state. I am not the company. Company is why the company has not released the gratuity. They can satisfy your question.
No, whether you have served upon the company?
No, company, my lord, I'm not the company, I'm the petitioner.
No, I know the petitioner who is appearing for the company.
Company, my lord. Sushant Pal, the last
I am
time.
appearing on behalf of the state.
Okay, but last time they took the time for filing affidavit of oppositions because it's
Yes, sir. Thank you.
Sujit Shankar Bole. That was appeared last 2020. His name is appeared.
The forfeiture may be done if the service has been terminated for the act,
For that.
for the
But here-
alleged act.
Alleged. But here, my lord, the disciplinary committee, this impugning order we have challenged, this forfeitures have been done when there is no terminations for any kind of negligence activities, and it is not even mentioned in that order.
Your lordship knows very well that so far the gratuity act is concerned, section 4 is very much clear. Allowed, unless and until, allowed, if there is any disciplinary proceedings, now the situation has been changed after by the special bench that been previously, my lord, after cessation of relationship, you cannot withhold the gratuity because so far the Bhogirath Jena and others matter is concerned. Subsequently, if any disciplinary proceeding is pending, it will be treated as continuous in service and disciplinary proceeding can continue, and thereafter, my lord, if it is held that he is guilty, then gratuity can be withheld. Only on the ground of moral turpitude, my lord, the gratuity can be
Forfeited.
forfeited and quantify the gratuity. Also.
Yes.
Yes.
But in this case, there is no such case. In this case, there is no such punishment like that, the termination of service or like that.
Then being the appropriate, being the employer, my lord, they will satisfy your lordship that while they have not released the gratuity.
My lord, this right to property is also come under Article 300A. This gratuity is also
That is
statutory
admitted.
right. Yeah.
That is admitted, that is not.
Yeah, the petitioner has been deprived of these things. And secondly, my lord, this loss and damage hasn't been quantified, and this even petitioner's case even doesn't cover under section 4 and 6, subsection 6 of the Payment and Gratuity Act. So they have arbitrarily, my lord, without even considering.
Where is the impugn memo?
This impugn order, my lord?
Yes, impugn order.
This impugn order starts from, my lord, page 34, my lord. And it was issued 2016, my lord. That's why we have challenged this arbitrary actions, my lord, by your filing writ petition, my lord.
One thing, it appears from the report of the inquiry officer at page 57.
Page
57.
Yes. Finding.
Charges for not taking, clause 2, charges for not taking proper action for submission of LC of /BG of page 2, paragraph 1 of the charge sheet, non-realization of OSD and not taking appropriate action for obtaining security deposit from Messrs. Shobha Ispat Alloys Limited and Messrs. Shobha Ispat Alloys Limited and showing of undue favor to Messrs. Sham Ferro Alloys Limited in violation of concerned regulation of work and against the interest of the DPL have been established in the inquiry. How much loss they have sustained, that has not been quantified.
Yeah, and kindly read, Manu, the last line. The charge officer violated the regulations 43V, 43, 43.5, 43.6 rules and 43.18 of the DPL, which I have shown, Mala, the DPL condition of service rules and conduct. And they haven't even complied with the even punishments things and even their own rules in terms of awarding this punishment to the petitioner.
Where is the punishment, award of punishment?
The punishment is, my lord, rule 44, my lord, is page 14.
No, where is the order? Order of punishment.
Oh, on order is, my lord, page 39.
Reduction of 75%
Yes,
gratuity admissible to her.
Yes, my lord. Now, kindly pass my essay order, my lord, because it is pending and this petitioner is, my lord, is a senior citizen, almost 69 years old lady, and she's still hoping that she will get some relief from this honorable court. Because whatever has been done with her is completely in contrary to law and even the respondents owns condition, service and conduct rules. I've shown some cases law, Mano, this has to be even regarding the rights of the gratuity and also the termination aspect, my lord. I placed some case laws before.
Authority held that charge has been proved, but they have taken the lenient view, considering because she has reached the age of superannuation. That's why.
So when he is the superannuation, before passing the order,
Yes, my lord. This was actually
when she superannuated,
30th June, my lord.
And 15 June,
is the order. 30th June is the date of superannuation.
Yes, my lord.
According to the rule, they may terminate the service, but they have not terminated. They proceeded to 70% reduction of the gratuity amount. That cannot do according to the Gratuity Act.
but I think after a long time the matter has come. And are they notice upon the
No, it is coming after in every week it is appearing.
Yes. Every
This is
week
parted matter.
parted matter.
This is parted matter. On finding the record, I find that there is no such AO. AO is not placed on the record. They perhaps not filed the affidavit, but they have filed the reply against the affidavit.
And they have given us a
It was missing. They said it is.
order your was please to direct them to reaffirm the
Yes, reaffirm. The last order I have directed
Yes.
to reaffirm and file the AO. It was not placed. What can be done now? At least one opportunity may be given to them. Direction is there to file the, that is the respondent number 226. You are respondent number
respondent number
1, I think.
1.
Leave was granted to reaffirm.
Yes, Malak. Malik, direction was there to file affidavit. They file affidavit. They serve to us. We have based on this. We file a reply. Malak,
It is
no
not
idea like why it is not available in the file. And again, they haven't come back to reaffirm and file it. They are simply delaying the matter. Malak, nothing else. This is complete their delaying tactics to
Very well.
drag the matter for past.
Please take down. respondent number 2 to 6
7 years.
was granted leave to reaffirm the affidavit in opposition. No such affidavit in opposition of respondent number 2 to 6 has been reaffirmed or placed on record. Full stop. None appears on behalf of the respondent number 2 to 6. State is represented through learned counsel. Considering the situation, the matter be adjourned today. The respondent number 2 to 6 is peremptorily directed to reaffirm the affidavit on the next within the 21st of 21st of November 2024. Let the matter appear on 21st. I will dispose of the matter on 21st.
Yes, my lord. Much obliged, my lord.
And one thing, well, she will start by notice upon
And this is part and matter, not necessary to serve the
What
notice.
it matter? They are only aware of. Yes.
I am appearing on behalf of the petitioner. Last question.
Lordship, on behalf of the state, led by Advocate Abhishek Prasad, Lordship, praying for a short passover, Lordship. Please kindly.
I'm appearing, my lord.
Oh,
Advocate Prasad is my junior. I'm filing my affidavit in opposition, my lord.
I've already filed the evident reply. Evident reply to file. The petitioner, it was heard by your lordship several times. The petitioner was appointed as a lower division clerk. Subsequently, he was promoted to upper division clerk. Thereafter, he was functioning in a promotional post since 2012. Till now, vacancy was created, but it was filled up by other wings of the Women and Child Development Department. There is no scope for further promotion of the petitioner to the superior post. On last occasion, your lordship asked me whether there is any possibility for promotions of the upper division clerk to the officer. I am placing two of the circulars issued by the authority. I've also prepared a short notes of argument. If your lordship can permit me to hand it over to you.
Yes.
I'm annexing that circular. Your lordship kindly come to 6 of the short notes argument dated 22nd September 2017. Administrative officer. Next promotion post is the administrative officer. By your promotions for eligible head assistant in irrigations or waterways type government, they have to follow the government rules, the authority concerned. One post of lower division assistant in the irrigation water. There is a scope for promotion from the upper division clerk to administrative officer. And second, circular I have already annexed 3rd day of January 2018. Assistant administrative officer method of recruitment 11A. By promotions from the eligible departmental candidates from the lower feeder post of head assistant to senior assistant, valuations, accountant, cashier cum storekeeper, by of selections considering seniority and experience, that is at least 5 years practical experience in the lower feeder post. And I've already elaborately submitting before lordship that petitioner was initially has been functioning to the upper post since for upper division clerk since for a long time being. But the authority concerns time to time by the authority concerns are taking steps to fill up the post from the other wings of the West Bengal Child Development Department. That is the subject matter of challenge of my writ petition. There is a scope, but in spite of that, the authority concerns issued a impugned memo by which they have taken steps to fill up the post from the other department. Without
That you challenge. That you have challenged here.
Yeah. Last talking only questions raised by your lordship, whether there is any possibility for upper division clerk to the promotional post admission. Next promotional post is admission. I've handed over to the in my short notes of argument. I've already annexed those to them. That is the only.
You have challenged the memo dated 14th June.
By which they have taken steps previously. There's no, they have not taken any steps to fill up the post or promotional post to from other wings.
26th May.
26th. It's the first time introduced by the authority by which the promotional posts are filled up from the other wings of the West Bengal child's welfare. Women and child development. The Women Child Development Department is consisting of 6 wings. The government, it is under the control of Women and Child Development Department. The authority concerned ought to have followed the rules which are framed by the state government. In a appointment, it has not specifically stated.
So it has been, it is the memo that the post of assistant project manager will be filled up on deputation by an officer belonging to the
assistant officer.
assistant project manager.
Administrative officer.
Dated
Dated 22nd September 2007.
No. Impugned memo is 26th May 2009.
2018
They have taken they have taken steps to fill up the post from the other departments.
Please write upon now in the written notes of argument. Neither he has annexed it in the
Yes,
petition.
It doesn't argue.
Affidavit.
No,
There is a
the
possibility
case is that petitioner has challenged the memo dated 26th May 2009, wherein it has been ordered under the governor that the post of assistant project manager and secretary has to be filled up by the other department on deputation. You challenge this order.
Yes. An administrative officer. At present, the post is lying back. Next promotional post is administrative officer.
Next promotion post to you, to the petitioner. But in the memo, in the alleged memo, they said about the assistant project manager.
It was filled up supplementary. In my supplementary, I have categorically stated. Now, what is that now? What is Paragraph 3, 6 August 2012, the project, the state government officer ex officio deputy secretary child development and women development and social welfare department government of West Bengal issued a memo being such and such. In the state memo, it has been stated that the government is pleased to transfer 16 numbers of officers belonging to the West Bengal Joint Junior Social Welfare Service to the new place of posting from their present place of posting. It also appears from the said memo that one Ruma Rai Chatterjee, who has been functioning as DPO under the Child Development and Women Development and Social Welfare Department in the district Birbhum and has been transferred and posted to project manager in the Women Development Undertaking. And next para, that on 16 March 2015, the Joint Secretary Government of
You are reading? You are reading which
supplementary,
supplementary?
which is found. Post was created, but that was not filled up from the department promotional basis. They are going to take steps to fill up the post from other wings. That is the main contentions of the these petitions. That is my supplementary. That is the purely violations of natural justice. In the appointment, it has been categorically stated the authority council ought to follow the government rules. Same benefits will be given to the employees of the
Child development.
Child development.
The women and child development.
West Bengal Women Development Undertaking.
Petitioner is before the read court that his promotional avenue has choked. That is the only.
Due to illegal activities on the part of the respondent authorities by issuing this memo.
Yes, what is your submission?
Kindly come to my affidavit in opposition. Paragraph 4, clause 9. He was appointed to the lower post of lower division assistant of the undertaking by virtue of notification number such and such, and as mentioned in clause 1 of the table at point 9 above, he joined the post on 23rd March 2007. He was then promoted to the post of upper division assistant of the state undertaking on 30th March 2012 by virtue of the memo number such and such dated 20th February 2012. The amended procedure of filling up the post of upper division assistant of the state undertaking as mentioned in clause 7 of the table at point 10 above. At the present, there is no scope for promotion from the post of upper division to any post of the state undertaking. Now, my lord,
So come on next day.
Yes.
Next week.
next
Okay.
week, my lord, 21st, I have submitted the 28th. I was already 28th.
28. Let the matter appear in the list on 28. Yes.
Remember, India of India's decision, wanted I have recent yesterday. There are some urgencies that you also state the suspension order. I have to come, I have to, until unless you also pass an order to solve. I cannot serve. You also can direct me to solve a copy of the contempt, let the matter appear on Tuesday again. Order passed by your lordship in the sit on 28 August 2024, sitting in the vacation bench, thereby staying the suspension order.
Yes.
Till today, no allotment has been made. Neither the dealers has been tagged. A rationist has been tagged. File to the contempt. Get the order passed by lordship case 13. Case 13, 1 3. It has been extended.
Now, what is the order? The order of suspension was till the urgent date.
And subsequent that has been extended. You will get it the extension at page 16 on 30th. till 30th November. Extension is up to
30th November.
November.
So what is the your grievance now?
Till today, neither I have not been allowed to resume my business. No suspension order has not been stayed, has been stayed by your lordship, but they have not neither tagged the ration cards with me or not make any allotment by the ration officer. That's point number 5.
The ration cards were tagged with other persons.
That has been tagged temporarily. That has been retagged with me.
No such order is there in the.
Suspension order state means meaning thereby is that if there is no suspension order,
Okay, please take down. The instant contempt application has been preferred by the petitioner for violation of the order by the alleged contemner. For alleged violation of the order by the contemner, dated 28th of October 2024. Having heard the learned counsel for the petitioner, also perusing the impugned order dated 28th of October 2024, petitioner is directed to serve the contempt application upon the alleged contemner. Let the matter appear in the list.
Wednesday, I will do it within a day. It is in Joda Shako.
No, not understand. Next week,
Next week.
not thereafter.
Oh, well, next week there is suspension. Could not be able to run my business.
Wednesday, I have 20th. I have already fixed several matters.
It's a let the matter appear any day next week, subject to convent of your lordship.
Come on, 26th. It will
Well,
be better.
that's it.
26th.
I'm grateful. Much.